Good afternoon, everybody. I'm your host, the Supreme Litigant. I'd like to thank everybody for subscribing to my channel and commenting and giving me thumbs up on the content that I provide for y'all. If you haven't already, please go ahead and hit that like button and that subscription button. I'll give y'all a second to do that before I begin with the topic of the video. All right, now let's jump right into this. Today I'm going to be teaching y'all, where is it at? Right here. We're going to look at this case right here. Now, these are all Alabama cases. Before I do that, I'm going to go ahead and give y'all the case citations. These notice how old these cases are. They're very old. Well, the first two are anyway. But I'm going to be reading an excerpt from all three of these cases. This case I want to focus on. This is a case in which the legislature is acting outside of their delegated privileges invested into them or entrusted to them by the sovereign people of Alabama. So they got to be checked. And I want y'all to see this because this is what this so-called judge is going to tell you. So the title of this video is going to be called The People versus the Legislature. That's going to be the title of this video. So it starts on page 9. Y'all can read this case if y'all want to. Here's the case citation right here. And then it should be up here at the top of the page too. Well, no, it's not. But anyway, this is the case citation right here if y'all want to read it. Now let me go ahead and let's get to page 9. All right, and it's going to start. I'm going to start where it says right here. This is where I'm going to start right here. For the security of the judiciary itself, one of the greatest coordinate departments, the people, in their constitution, have expressly guarded and restricted the power of the legislature. Let me read that for y'all again. For the security of the judiciary itself, one of these great coordinate departments, the people, in their constitution, have expressly guarded and restricted the power of the legislature. This department, the legislature, has always claimed to be the people, and it has often invaded the rights and authority of other departments. It once elected the judiciary, but the people took from it that power. Let me read this. Let me start right back up here again, because this is the same exact thing that they're doing today, y'all. This department, the legislature, has always claimed to be the people, and it has often invaded the rights and authority of other departments. It once elected the judiciary, but the people took from it that power. The people took from it that power. The people took. The people said, look, you irresponsible, tyrannical idiots, don't know what you're doing. So we're going to take this back from you because we can do that because we're sovereign. They took that from them. It once had unlimited control over the tenure of inferior judicial officers, judges, and the people restricted this power. It once had unlimited control over the tenure of inferior judicial officers. Inferior judicial officers are so-called judges in these administrative agencies that they're calling courts, by the way. Judges. And the people restricted this power. The people now elect all the judges and every man duly qualified and placed in office by the vote of the people. That is, I might have read that wrong. I'm going to read it again. The people now elect all the judges and every man duly qualified and placed in office by the votes of the people is a judge. I might need to read it a little bit more. The people have further restricted the power of the legislature to remove the judges, not only by securing the tenure of their office, but also by prescribing express rules and conditions in respect to removals by the Constitution. In this case, the legislature has legislated so as to the removal of a judge from office, which is unlawful because the Constitution restricted them from doing that. The people in their Constitution restricted them from doing that. Hey, you're not sovereign. You can't do that. We don't want you to do that. And we know you did it in the past, and we don't like the way that you did it. We don't like what you're doing. So we're gonna put your ass in check by changing this Constitution and taking that privilege that we gave you away because you acting like a damn child, want everything to go your way. They have abandoned the judicial functions of address and impeachment conferred on them by the Constitution and have ignored the rule requiring 2/3 vote of each house and forgotten that the governor must remove the consured incumbent and have attempted to vacate his office by repealing the law that established this court. And they're talking about a statute, by the way. So that's all I'm gonna say on that. Let's go to the next one. Where is this next case? Is it Broadway? I think it's Broadway. Or is it Dunbar? Now I'm not gonna read y'all this one. This one doesn't really get into the legislature, but it does point out something very interesting that I want y'all to see. I'm gonna do a video on it later. Let's see. Right here. I'm gonna stop right there because this is what I want y'all to see. The cases arising under the Constitution, the cases arising under the constitutional grant are distributed by the General Assembly among the different circuit courts according to locality, and jurisdiction of the person is acquired by proper service of legal process or by consent. So no, you are not crazy. We're not crazy when we tell people this. We're not crazy. Here's the case citation right here. There's the case citation. Let me go back up just so y'all can see it, so y'all don't think I'm making shit up. This is the case citation. This is the case citation. But I don't want to get off topic, so I'm going to focus. Let me go back to Broadway. Okay. Let's see. Now, notice there's a lot of censored stuff in this case, y'all. I had to go to the law library to see what they had censored, and to actually see if in the book that they had also censored this. They didn't do it in the book, and I'm not going to talk about it here, but I am going to. I'm gonna focus. So I want to stay on topic, stay on point. I don't want to get off point. Where are we? We're going to go down right here. All right. It is well understood in this state that the legislature has plenary power to legislate, except as that power is restricted by the Constitution, either of this state or the United States. Okay? Everybody know that, right? Everybody know that. Section 42 of the Constitution divides the power of the state into 3 distinct departments, each of which is confided to a separate body of magistracy. They're all public servants, y'all. Just to let y'all know, they're all magistrates. The judge, the prosecutor, everybody in the House, everybody in the Senate, the governor, the mayor, all of them are magistrates. A magistrate is just another word, if I'm not mistaken, for a public servant. But anyway, to wit, those which are legislative to one, those which are executive to another, and those which are judicial to another. And Section 43 of the Constitution prohibits any of them from exercising the powers of the other. Just to let y'all know, y'all already know this, but administrative agencies, which are members of the executive branch of government, exercise all 3 powers of government. But they call it quasi-legislative and quasi-judicial authority. Scroll down. Section 139 of the Constitution declares what shall constitute the judicial power of the state, which includes the Supreme Court, the circuit courts, and other courts there named. It was said in the case of Perkins versus Corbin, 45, 102, Alabama, page 118, which is the case that I just got off of, if y'all didn't know. Just to let y'all know, right there. That's the case. That's the case I just got off of. I didn't read y'all. I'm going to read y'all something from that case right now. But aside from this objection, the petitioners claim the courts of this state are not only divided into courts superior and inferior, they are of different characters. Some are established by the Constitution itself, that is, by the people. So hold up. You mean to tell me that the people can make law? How can the people make law if your public servants are claiming that we're not sovereign? How can we make law? And how can our law be superior to their law if they're sovereign and we're not? It makes no sense. It makes zero sense. That's because they're lying to you. They do not depend on legislative enactment for their existence. They are created at the same time and in the same way with the legislature itself. What? Really? What? I hate to be so animated, but people think that we crazy, y'all. So I have to go in and I have to show these motherfuckers that we not crazy. They think we crazy, y'all. They think we just be making this shit up. But notice it's the people who don't really read the stuff, or either they're the so-called judges who know this stuff and they're just gonna participate in a form of treason. It seems like a form of treason to me. But anyway, I'm gonna keep reading. I'm not gonna stop no more, y'all. I might a little bit. Let's see. They are of the same grade in the sovereign power. They are a constituent branch of the government itself. The government under the Constitution is not complete without them. These are the Senate sitting as a court of impeachment, the Supreme Court, the circuit courts, the chancery courts, those are equity courts, by the way, and the courts of probate. Probate is where you're going to execute your wills, and I think they adjudicate trust too, if I'm not mistaken. These courts do not owe their allegiance. I'm sorry, let me rephrase that. These courts do not owe their existence to the legislative power, and the legislature cannot dispense with them or abolish them. I wonder why cannot the legislature do that? They are emphatically the people's courts, and they proceed directly from the sovereign, aka people's will. They constitute a coordinate and independent department of government, and there is no other department of the government that can abolish them. The people alone, in whom is the ultimate sovereign power, can do this. They are each, in their way, constitutional elements of the state sovereignty itself, as represented in the government. Let's go down. There's a little bit more I want to read to y'all. A little bit more. It has been the firm understanding of the courts in the interpretation of the Constitution that those courts which derive their existence from the Constitution, succeeding common law courts of historic origin, cannot have their functions and their orderly process disturbed by any legislative enactments. The principle is stated in 21 Corpus Juris Secundum Courts, section 122, page 188 to 184, and follows. Hence, the universally recognized rule that, except insofar as it is authorized to do so by the Constitution, the legislature cannot diminish the essentials of the judicial. No, let me rephrase that. Cannot diminish the essentials of the jurisdiction functions, or judicial powers so conferred on them, nor abrogate or abridge their inherent powers or functions. In other words, the legislature cannot take from courts power which it does not give. Y'all paid attention? This is why I tell y'all, and why I told y'all in some of my videos, that the legislature is creating courts, so-called courts. Let me rephrase that. The legislature is creating administrative agencies and calling them courts, and are investing in these administrative agencies quasi-legislative and quasi-judicial authority. These administrative agencies are a part of the executive branch of government. They are all corporations, they all have DUNS numbers, and they all have EIN numbers. They ain't no different than a private citizen because they are using negotiable instruments, commercial paper. Let's see. I think that was good on this one. I think I'm gonna do another video. I probably got time. I don't know, but that'll be the end of this video. I hope y'all enjoyed that. This is why I tell y'all to go and read these old cases, because they're gonna let you know in the old cases. They just flat out tell you. They really didn't sugarcoat too much in the old cases. But if you want this case citation, it's Broadway versus State. Let's see if I can find it right here. Here it is, Broadway versus State, 257 Alabama 414. This is a Supreme Court case too, by the way, in Alabama from 1952. You need to go down to your local law library. You need to read these old cases, and they'll tell you exactly what happened. But anyway, that will be the end of this video. The Supreme Litigant is out. Peace.